Can I just open the meeting, welcome everybody and thank you for attending, and can I also welcome those people that are watching this meeting via the webcasting. As normal, can I ask everybody who's got a mobile phone on them to make sure the phone's switched off? And before we go on to the agenda items, I do have to read out a statement. We welcome the use of the Welsh language at the public meetings. I have not received notice that members or invited attendees wish to use Welsh today, and therefore the meeting will be conducted in English only. Thank you. The agenda attendance, have you had any apologies for absence?
Apologies received from Councillor Graham, and Jessica Powell is just running a bit late.
Right, thank you. Declarations of interest?
Thank you, Chair. I'm not aware of any interest the members need to declare. Thank you.
Thank you. Item agenda 3, minutes of the meeting, of the last meeting, starts on page 3. So if we go page 3, page 4, page 5, page 6 and page 7. Everybody happy that that's a true record? Anybody have any items that they wish to bring up on it? So we're okay on that one. Item agenda 4, action sheet. Helen?
The response from recommendations from our last meeting have yet to be received. As soon as they are, we'll forward them to members.
Thank you. Item agenda 5, which is a licensing update. If you remember, 18 months ago, we scrutinised child sexual exploitation, and we made a recommendation that all taxi drivers should have mandatory training. So I'm just reporting back, because I attended the licensing committee last week, and it was reported that to date 222 drivers have actually had training, which is absolutely brilliant. And more importantly, the police are actually reporting that they are getting information now from taxi drivers as a result of that training. So I think it's a perfect example of how scrutiny, we make a recommendation, it's accepted, it's implemented, and it's actually made a real change. So I think the Healthcare Committee should receive a pat on the back for that. Just a shame we didn't have that when I did the report to Council a couple of weeks ago, because if we had it done, we might have got well done. Barry Taylor.
Chair, on that information you gave 222 drivers, but out of how many drivers?
Out of 220 out of 254. So it's the majority. And there's obviously ongoing training, so those that have Sorry, so out of those that haven't had it, there are plenty of times over the next few months to have it. Okay? Sorry, now go on to item agenda 6, which is the deprivation of liberty safeguards. Our invitee this morning is Tom Grace, who's from the Aneurin Bevan Health Board. Thanks ever so much for coming. Are you quite happy for us to call you Tom?
Yeah.
Great, thanks. Just to let you know, we've obviously all read the report, and myself and 2 officers, we went to visit a care home last week just to get the how it works from the care home side. So we've done some research on it. Unfortunately, if I explain to those members who weren't here on Monday, unfortunately, we only got the phone call in the morning that we could visit in the afternoon, so it wasn't time to contact other. And also, I don't think it would have been appropriate for lots of us to turn up there.
Do you have a copy of it? So not the author of the report, you know that, don't you?
Yes.
Okay.
Tom, can you, before we go into the questions, can you just explain what your role is and everything? Thank you.
I'll just press that, do I? Okay, right, okay. So my name's Tom Grace. I'm a mental health nurse by profession, so that's my background. So my background is in mental health care, mainly with an Iron Bevan Health Board. So my role is, I'm head of the kind of clinical management arm of the Deprivation Liberty Safeguarding team. So what I manage is the assessment team, which is part of the DOLS panel consortium. So we have a consortium with 5 local authorities and an Iron Bevan Health Board. So we receive all the requests for assessments on behalf of the 5 local authorities and an Iron Bevan Health Board. We then allocate those assessments to a best interest assessor who coordinates and undertakes the assessments on behalf of the 6 supervisory bodies. So a supervisory body, are you familiar with the term supervisory body? Okay, I don't need to go into that then. Okay. So we basically work on behalf of the 6 supervisory bodies. And my role is to manage the best interest assessors, the team. Okay.
That leaves me happily answer the first question. Do the best interest assessors working for you have other roles, or are they purely on the DOLS team?
So no, so the way, shall I give you a history? So I joined the team in January 2014. So when I joined the team in 2014, there was one other best interest assessor. So I joined the team, and that made, I'm a best interest assessor as well as managing the team. So that was the resource that was available for the whole of the Greater Gwent area plus the health board. So for 6 supervisory bodies, there was only one best interest assessor plus myself. That was in 2014. The other people, my understanding was other people had been trained, and but they had generic posts. So there was a problem in terms of people not being able to be released from their generic role to undertake assessments. But because of the nature of the work coming in, before the Cheshire West judgment, there simply wasn't a need to expand the team. So after the Cheshire West judgment in March 2014, of course, there was, the capacity, basically went through the roof in terms of the numbers of people that needed to be seen. So the partnership consortium, the panel, decided that we would need more staff. So they speculated about 2 different models, basically. One model would be where we had a pool of best interest assessors that had generic roles, but they could also come and do some assessments for us as well. And the other model would be around people who were dedicated and purely worked as best interest assessors. So my understanding was that the partnership had struggled with having a pool of assessors because people just simply couldn't be released from their generic role. So what we have now is we have I suppose, a dual system really. So we have 4 dedicated best interest assessors, plus myself, that are employed by an Iron Bevan Health Board, but on behalf of the panel. And their role is just to do best interest assessors. Additionally, there's been an agreement that where the supervisory bodies could and were able to, they would second somebody in from their teams to work purely as best interest assessors. And we've had some success with that. So some people have come in for a couple of months and then they've gone back to their generic role. So at the moment, we have myself as the team leader. We have 4 dedicated best interest assessors that are employed by an Iron Bevan Health Board, and we have 4 people on secondment with us. One of those is due to end soon. And then outside of that, there's been an attempt to train other people. So Blaenau Gwent and Caerphilly have recently trained a cohort of professionals. Prior to that, Torfaen and Newport trained some professionals, and prior to that, an Iron Bevan Health Board led. Those people have been trained to be part of a wider pool. We've not seen much yield yet in terms of those people picking up assessments, and that's probably mainly because with the Caerphilly and Blaen y Gwent cohort, they've only just done their training, and it's not been made clear to us yet whether those people are going to be available to us to do best interest assessments. And with the Torfaen and the Newport cohort, we've had yielded about 8 assessments off the top of my head. And the reason for that, again, is that, of course, I manage the team that does best interest assessments under what's called Schedule A1. You familiar? Yeah. And whereas what the Cheshire West judgment did, of course, it extended the deprivation of liberty safeguards to supported accommodation. And certainly in some discussions I've been made aware of course, the local authorities have been in a situation where they've needed to identify best interest assessors to undertake those assessments, which of course have to go to the Court of Protection. So, like I say, you know, those assessors haven't really been made available to us to utilise it as yet.
How much engagement is there with the relevant individuals' families?
The families have to be assessed as part of the process. The best interest assessor and the Section 12 doctor, as part of the assessment, is that they have to consult as widely as possible. So they have to consult with not only relevant family but relevant professionals, relevant carers, and that, of course, that has to be documented in the assessment. If people haven't been able to be contacted or consulted with, then there has to be it has to be documented on the assessment form. So, if, say, for example, somebody who's involved, an important person involved in somebody's care hasn't been consulted, a note has to be made why they haven't been consulted. And of course, one of the other reasons is that when people are deprived of their liberty, when the authorisation is granted, a representative has to be identified. Now, normally, that representative would normally be a close family member or relative. If, however, there's been recent case law that's indicated that where a person is objecting, and their relative wouldn't be prepared to support them to object, then they can't be appointed as a representative, and that's because of Article 5.4 of the European Convention of Human Rights, that if somebody's objecting, they have to be given a chance to appeal. And of course, there's been some conflict in the court whereby, of course, if somebody's in a situation where they've struggled over many years to find an appropriate place for their nearest and dearest, and their nearest and dearest are then objecting, of course, you know, it causes a conflict, you know, with the person who maybe thinks it's in their best interest to be in a care home, but of course that they have a right to appeal, so we have to appoint, or we have to advise that an independent advocate is appointed so that the person can access their Article 5.4 rights.
Have we had any appeals in Torfaen?
I couldn't comment locally on, probably Sarah Patterson is probably the best person, but what I would say is that since the what's called the AJ case, which was the case that and a case called the Neary case, it's identified that it's no longer good enough for a local authority supervisory body to simply wait for somebody to appeal. If somebody's objecting, the law states that it's up to the local authority, the supervisory body, to take the impetus to take the case to court to demonstrate that its arrangements are appropriate. And again, that's this kind of idea that you shouldn't be, again, a human rights issue, that we shouldn't be in a situation where we're waiting for people to go on their own and take them out of court. We should be supporting them and helping them.
Sorry, Chair, I know it's following on with your question of appeals, but I was going to ask then how many appeals have been successful. So would you know how many successful appeals there are?
I wouldn't know. I mean, obviously, if I'd been asked that prior, I could have brought that information.
Yeah.
But of course, the appeal is about, under Article 5.4 European Convention of Human Rights, anybody has a right to challenge a deprivation. So the issue is about, the best interest assessor assesses whether the arrangements are in the person's best interest. Yeah. But of course, the person has a right to appeal that, and if it is overturned, then the person, you know, is in a situation where they would need to be moved because the care arrangements are not in the person's best interest. But I couldn't answer the question. Sorry.
Chair, following on that, you know, I know you haven't been able to provide us with this, but you know, when you go for appeals and all this takes a long time. It isn't, you know, done within a week that you can put things right. So how do you cope with the situations there then?
Sorry, before you answer that, perhaps I can come in with another question. You explained earlier about how your team is made up. How are you going to cope with the backlog? And how are you going to cope with all the extra work that's coming in? With, as you said, you've got some who are trained but not actually doing their job yet, and with the appeals potentially coming in.
Okay, so with the appeals, our team is not part of that process. So the appeal is made, is something that your legal team will deal with. The appeal is not to us as a best interest assessor. The appeal is against you as a supervisory body. So what's happened, the process is that the best interest assessor has undertaken the independent assessment. So the basis of the deprivation of liberty safeguards are that what we have is we have an independent assessment which to identify whether the arrangements are in the person's best interest. You as a supervisory body authorise that, and the appeal is made to you as a supervisory body because you've authorised the deprivation of liberty. So your legal team are the team that would pick that up and take that forward, not our team, so to speak. You know.
Right. I don't want to get bogged down too much in appeals, but out of all the referrals that are coming in, they're obviously increasing by the day. How are we going to cope with those referrals?
Well, I suppose the long and the short of it is that it's an unprecedented, it's a national unprecedented situation. I think, you know, the national report indicated that there'd been a 16-fold increase across Wales and England. What we've tried to do locally is we took some legal advice and we developed a scrutiny tool, so that what we could do is we could identify those people who were perhaps more in need. So where their deprivation was indicated, I think you've got something in your pack about the scrutiny tool. So that of course, we were concerned that sort of there would be a cohort of people whose deprivation would have changed basically because the rules have changed. But they would have been in situations where they were in settled episodes of care. They weren't necessarily objecting. But there would also be other people who were deprived of their liberty where they were maybe in a situation where they were subject to high levels of restraint, medication, they were to manage any conditions that they were maybe subject to one-to-one observations. So we felt it was important that we designed a tool to make sure that we were able to assess those people who were perhaps more in need, let's say, you know, whilst accepting that obviously the other people, you know, needed an assessment as well. So that assessment, that scrutiny tool was picked up by Welsh Government and the Department of Health, and it's a national standard now. So in terms of trying to manage that backlog, probably the best thing we've been able to do is to adopt a method where we scrutinise those who are more in need. In terms of clearing the backlog, the only realistic way of clearing that backlog is for us to have more staff to undertake assessments, unfortunately. What happens as well is it's not a static assessment. So the maximum that a dole can be authorised is for 1 year. So that after a year, that will come back for renewal. So it's a number that isn't kind of going down, so to speak, unless, you know, goodness forbid somebody passes away, you know.
When they're doing the assessment, how much time is actually spent with the resident?
As much time as is necessary. Obviously, the best interest assessor and the Section 12 doctor, you know, they're professional people, so they're trained mental health professionals. They're trained to engage people. So as much time as is needed is the answer to that. So that could be a long period of time, that could be a short period of time, and it would depend really on the person's ability to engage as well.
I was really concerned when we went to the care home last week to be told that only a small proportion of time is actually spent with the resident, and most of, in fact, 99% of the information is taken from the patient's notes. That was really I was really concerned when we got that information.
Well, I would be concerned because the role of the best interest assessor, the best interest assessor has to scrutinise the notes. The best interest assessor, their role is to assess to see whether a deprivation is occurring, and also to ensure that the care is in the person's best interest. Now, from a safeguarding perspective, the evidence of the person's care, whether their care actually amounts to a deprivation of liberty, will mainly be contained in their notes, so their care plan. So does their care plan indicate that the person is being deprived of their liberty? Does their care plan indicate that their care is being delivered in the least restrictive and most appropriate way? And so, as you know, with regard to sort of any sort of care that's delivered, care has to be documented appropriately. There has to be evidence in the notes that says a capacity assessment has been undertaken, an appropriate care plan has been formulated, that care plan meets the person's needs, that there's evidence on a daily basis that that person is receiving the most appropriate care. If the best interest assessor doesn't scrutinise the notes, then they can't walk away and satisfy themselves that they've examined the person's care appropriately. So, I mean, I would reject that you know, that's the case wholeheartedly, because if the person, you know, the person is important and central to the assessment, but it's not just about how the person presents, it's about the care that they're receiving and what's been documented. So unless we scrutinise the person's care, we're not in a position to walk away and say that it's definitely in the person's best interest. We wouldn't be able to pick up on things that maybe were irregular. So that would be my answer to that. Yeah.
Do you think you've got the balance right on that then, in your view?
Well, I mean, all our assessors are trained and accredited. I mean, they're professional people. I mean, we've been, I think over the years when we've been scrutinised, we've been praised for our assessments. I would, you know, I'd defend that, you know. I don't think it's, in terms of our clinical practice, you know, yeah, definitely, yeah.
Okay, thank you. Is the increase in longer length dolls in the best interest of the relevant person?
Sorry, say that again?
The longer length dolls,
Yeah.
are they in the best interest of the relevant person?
Well, it's important to remember that the best interest assessor formulates an assessment that comes to the supervisory body signatory. So the supervisory body signatory receives a recommendation in terms of what they... So the authorisation is granted by the supervisory body lead, so your lead would grant that. So we would make a recommendation based on the person's particular circumstances, and that would either be endorsed or not by your lead. So it's I suppose a double check, for want of a better expression. So I suppose what we would do is, so where somebody's in a settled, you know, they were in their care was settled, their needs were being met, and their care seemed appropriate in their best interest, it would be reasonable to say that, you know, we would recommend that the authorisation should be for a year, which would be the maximum. Contrasting that, because obviously we assess people in all sorts of environments. If recently I've been to assess somebody with an organic brain injury. So what we know about people with organic brain injuries is that they have the potential to regain capacity. So it would be completely inappropriate in an acute environment to recommend a deprivation for up to a year. That would need to be appropriate to their recovery and their needs. So we might recommend something between 3 and 4 weeks, say, for example. So it's depending on the person's circumstances and what's going to be in their best interest.
Number 12.
Do you feel that there are delays in respect of the 21-day decision time impacting on the lives of the individuals?
No. I mean, it's difficult to generalise, but what I would say is good care planning, and good care, should be delivered in accordance with the general provisions of the Mental Capacity Act anyway. So if people have applied the principles for caring for people who lack capacity, then there should be no reason to think that there would be, that care shouldn't be delivered in an appropriate manner, in an appropriate way. But of course, what's missing is that independent check, those independent safeguards in a timely way. And of course, that's an opportunity to highlight if there's anything amiss or anything that isn't appropriate. So I think it's a difficult question for me to answer. But I would have to say probably, yeah, because people are not under those safeguards.
Just a crunch question then. Do you think DOLS delivers what it's supposed to, or is it just an administrative tick box exercise? Because, okay, I'm not a clinically trained person, but when I went through these forms, it did look very much like a tick box exercise. Is the system delivering what it's supposed to?
Again, what the system is intended to deliver is intended to deliver a human rights-based approach to vulnerable people. So, in that context, my view would be that people who lack capacity, people who are reliant on other people to make decisions about their care, are probably the most vulnerable people in our society. If that means that we go through a rigorous process of doing an independent safeguarding check to make sure that decisions have been made appropriately and that people are given the opportunity to appeal those, I would say yes, it does, because it's based around a human rights-based approach. So although the forms might look bureaucratic, the actual assessment is about trying to highlight if there's anything amiss with somebody's care. If people aren't receiving the right care in their best interest. And I suppose the best answer I can give to you is that where we've gone to assess people and it's been obvious that their care hasn't been in their best interest, and we've felt that people should either be moved or their care should be changed, and that's happened, then those people have been safeguarded. So whilst maybe for every 100 people that are assessed, maybe 99 of those people, their care would be appropriate, for that one person where their care wasn't appropriate and something was changed as a consequence, I would say it works for them. But you have to assess everybody to make sure, and from a safeguarding perspective, we have to assess everybody to make sure we safeguard one person, don't we? And that's the nature of things, I would say.
Chair, thank you. Tom, can I ask you, the phrase itself, deprivation of liberty, sounds a bit almost draconian, a bit nasty almost. Is that in the report on page 24, saying about the Law Commission report that they want to change it to a system and with the much better name of protective care. Do you think that the phrase that we should actually change, that the phrase deprivation of liberty should be taken, that we should relabel it from deprivation of liberty to protective care?
I think it's a good point, actually. I think one of the obviously, we inherited this. Government came up with these guidelines. Government produced this mechanism. One of the most alarming difficulties we have as best interest assessors is having a conversation with relatives, and when relatives are faced with this kind of notion that their their nurse and nurse are deprived of their liberty, you know, it's in stark contrast to the fact that what we're actually attempting to do is attempt to provide holistic care for somebody in an appropriate care environment. So yeah, I think you're absolutely right to point that out, and it's been pointed out, you know, as an alarming issue in many quarters. So I think the Law Commission are right to take that on board to try and change the nature of it. But I suppose the danger of that is that we don't water down the seriousness of what we're talking about, because the reality of the situation is that people who are vulnerable and people who lack capacity, they are deprived of their liberty. People aren't allowed to leave these places, you know, with free will. So it's important that we recognise, I think, what we're actually imposing on people, and that we're in a situation where we take it serious enough to undertake an independent safeguarding assessment to make sure that those arrangements are in the person's best interest. I think there's always a danger that if we try and water things down, you know, we kind of miss the, you know, the real nub of the issue, which is about protecting people, you know. But no, my understanding, I mean, the Law Commission are due to publish soon, so we'll see what they've come up with following the consultation. Yeah.
I think it's fair to point out that the care home visited last week, if a resident went to the door and said, I want to go out, they wouldn't be stopped, but a member of staff would go outside with them and they'd walk around the car park, and invariably after 10 minutes, I think, well, there's nothing much here, I might as well go back inside. But so they're not actually stopped going out, but a member of staff would always accompany them. So I think we need to get that into perspective. Does anybody have any other questions for Tom before? Tom, can I just say thanks ever so much for coming. You've been really, really helpful, and the information you've given us has been invaluable. Thank you. Hi Sarah, welcome, and Keith. You've been to the Scrutiny Committee before, but can you just explain your role in respect of dolls, please?
I'm Group Manager for Adult Services, and in my portfolio I'm the lead, the professional lead for all things Mental Capacity Act, which dolls comes into.
One thing just to give you the background, we've had the report, but I had the opportunity last week to actually visit a home and talk through the process from the aspect of the care home. So how much engagement is there with the residents, the families and so forth in this process?
The managing authority, which is the care home, has a responsibility to engage with families, to let them know that they are making an application to the dolls team. But at social care staff, the social workers that are doing the assessments for people to go into care homes, if it appears that the person will be deprived of their liberty in such a care home, then they too should be discussing that with the families to explain to them all about the deprivation of liberty safeguards. Unfortunately, and as an unintended consequence, I think families view the deprivation of liberty safeguards in quite a negative way, actually. Rather than it being a safeguard for that person, it's seen as quite a negative thing. And certainly that was something that the Law Commission found when it was doing its consultation. And that's, you know, it's unfortunate, and we're hopeful that any new scheme in the future would operate in a way that changed that.
How about appointed advocates?
When somebody, an authorisation is given to deprive somebody of their liberty, the person, who's called the relevant person, we, the supervisory body, are required to appoint a representative. Now that can be, the best interest assessor determines who that representative should be. It can be a family member, and so it's the best interest assessor that will have that discussion with the family member to see if there's an appropriate person that can undertake that role. But it's a very specific role, because it's all about making sure that the person who's deprived of their liberty can access, if they need to, if they want to, the courts to have that deprivation reviewed. If there isn't a family member who's appropriate or willing to undertake that role, then we appoint an independent mental capacity advocate, and we have a commissioned arrangement with an advocacy service, and you'll see in the report that actually our current advocacy provider has given us notice on that, and we're going out with Newport and the other Gwent authorities. Newport are leading to find a new advocacy provider, but there is an interim arrangement in place. Nobody's been left without an appropriate advocate.
How does lasting power of attorney affect the DOLS process?
If the person has made a lasting power of attorney, and so there is an attorney, then the best interest assessor will consult with that person. It would be an attorney under personal welfare, not finances. They would have to consult with that person, the attorney. But actually, as long as when they made that lasting power of attorney, it doesn't conflict with a DOL, then it would go ahead.
If you look at paragraph 15.4, bullet point 4, how does the Mental Health Act conflict with the DOLS authorisation?
Can you tell me the paragraph again that you want me to look at?
4.15. Yes, it's on page 22. It's at the top of the page, the third point down.
There's an interface between the Mental Health Act and Mental Capacity Act deprivation of liberty safeguards. So you can't be on both. So if you're deprived of your liberty in a psychiatric psychiatric hospital, then really it should be the Mental Health Act that has primacy, that should be considered and used. And that, on the whole, is what happens. Our DOLS team, if a referral comes in from a hospital setting, that's one of the things the DOLS team must consider. Could the Mental Health Act be used in this case? Because that provides safeguards for the person. They have a right to appeal to a mental health review tribunal. So really, people in psychiatric units, you would look at the Mental Health Act first. People in other settings, you would then have to consider which of the two pieces of legislation is the most appropriate. Actually, that's very complex, but we do look at those things. Approved mental health professionals, best interest assessors look at that, and then whichever piece of legislation is deemed to be the most appropriate is what's taken forward.
But the fact that the person's been referred means that they can't fall in between the two of them. They will be one or the other.
Both pieces of legislation will cover most people. It is possible to fall in between them if staff don't recognise that one or other applies. So it wouldn't be true for me to say people couldn't fall in between them. But on the whole, people don't.
You'll be pleased to know it's the last question from me. How does the Social Services and Wellbeing Act affect dolls?
I think in the way that other pieces of legislation have obviously been repealed by the Social Services and Wellbeing Wales Act. Deprivation of Liberty Safeguards Mental Capacity Act hasn't. Actually, the Social Services and Wellbeing Act very much talks about being very person-centred and what matters to people. And the assessments that are undertaken for dolls need to be undertaken with that in mind. But certainly the new legislation hasn't repealed dolls. Dolls still stands as it is.
Following on from one of the questions that Councillor Mills asked you, you said that families were more on the positive side, not the negative side of it all. What do you mean by... sorry. What are the negative sides that people do not like about it?
The use of the language is very difficult. You are depriving somebody of their liberty. That's a very negative way of saying, actually, what you're doing is safeguarding somebody's human rights. So that families don't like that. One of the unintended consequences also is if you die and you're still subject to an authorisation, that's notifiable to the coroner because it counts as a death whilst in state custody. And that's really difficult for families because it can add delays to arrangements. And whilst the coroner's office has to investigate, that there is that delay, and that's very difficult. We've tried with our partners to ensure that families know at the point somebody's an authorisation's made that this could be a consequence, so that they're not facing that news at that very difficult point. And we have a template letter that we've asked managing authorities, the care homes, to use, and we make sure our college GPs know as well that they have a responsibility to notify the coroner. Those are the two areas that I think families find most difficult.
I think we established when we were talking to Tom earlier that the title isn't the best title, and we were pleased to hear that there are things in motion to actually change the title of dolls. Mandy?
Yeah, hi. Moving on to the demand theme, on page 25, paragraph 4.24, out of 1,313 referrals made, Gwent-wide only 29 have been allocated for assessment. Is that correct?
No. There's in Torvine we have total of sorry, your pages are numbered slightly different from mine. That's why I'm struggling here.
Paragraph 424.
All right, thank you. Okay. So across Gwent, there's been, as of March, there was 1,313 referrals. That was all Gwent. Okay. The total number for Torvine is 219. These are the ones that are waiting. Of those, we've got 2 that are urgent, 3 that are high, 6 that are medium, and then there are 208 that are in that low category. The categories I think you'll see from the appendices. Any referral that comes in is screened and, if you like, risk assessed, so that across Gwent we are targeting the resource we have at those people who are in that sort of urgent high group in order to assess those people that are most vulnerable.
So, what are your plans to cope with the backlog then of the...
That's very much one of the reasons we wanted this to come to scrutiny committee. With the resources we have, what we've done so far is we've increased the number of staff within the DOLS team. So each local authority seconded an additional best interest assessor. That included Torvine for a 12-month period. Unfortunately, the person we seconded was in the team for 5 months before they went on to maternity leave, so that was unfortunate. That said, we are looking to second another person to do that. And across the partnership, but in Torvine, we have trained an additional 10 best interest assessors who will operate as part of the Gwent pool of best interest assessors. And so they were trained earlier in the year, and they've all gone through a consolidation and shadowing process, so they're now all able to operate as best interest assessors. But what is important for scrutiny to remember that this best interest assessor role is in addition to their normal role, and for some of them it's in addition to other additional roles that they also have, such as approved mental health professionals or practice assessors. So it's a big ask, frankly. And those 10 staff will be doing one assessment a month from that pool, but they're also available to us to do the assessments if we need to make court applications as well. So we have tried to increase the resource from the resources that we have in adult services. I think it's important to know, apart from about £36,000 that Welsh Government made available to train best interest assessors, and we've used some of that money, there's been no additional fund from either Welsh Government or National Government for us to cope with this very significant change. And it's the same picture across England and Wales.
Sorry, Manny, to butt in. Sorry. So basically what you're saying is because people are living longer, this is going to increase, the demand is going to increase. It's not, we're never going to catch up.
No, I think it is highly unlikely that we're going to catch up. You can only grant an authorisation for a 12-month period. And then they have to be the person has to be reassessed. So you're always adding to that number. And so at the moment, with the resources that we have, we're just about standing still with about 1,300 people across Gwent who still need to be assessed. So yes, unless there is either a change in the scheme and how we do it, yes, I think we will always be in that situation that we're never actually going to, with the resources that we currently have, be able to meet that backlog. So our response to that is the screening tool to say that we prioritise those people most vulnerable and therefore most at risk and in need of these safeguards.
Thank you, that's really helpful. What proportion of referrals are assessed and refused?
I'm not sure if I brought that data with me, and I don't know whether Tom was able to give you that. Very few, actually, that I'm an authorised signatory for DOLS. So actually, if anyone is assessed and the recommendation is that they don't meet the requirements and therefore an authorisation is refused, then I would sign that off too. They're a handful in the time that I've been doing this. And often of those that are refused, it's the capacity requirement that's not met. The person does have capacity and is able to consent to their accommodation, care and support, and therefore they wouldn't come within the scheme. That can be difficult for managing authorities because it's their responsibility to do that capacity assessment. And as we know, sometimes people's capacity fluctuates. So there aren't many that are refused.
So then they wouldn't come. What happens to them then? Do they stay in the care home?
Yes, because if they're able to consent to their accommodation and their care and treatment and they're consenting, then yes, that's fine. They're not deprived of their liberty, so they don't require or are eligible for the safeguards.
Thank you. Considering the number of low-risk referrals made, do care homes understand the criteria and the acid test and prioritisation system?
In general, yes. I think what care homes will probably tell you, though, is that because we've had to focus our resources on actually doing assessments, one of the things that we haven't been able to continue to do as much as we would like is to do that awareness raising and training with care home providers. That's not to say we haven't done any. I myself have been to our provider forum on 2 occasions to talk about deprivation of liberty safeguards, and we've also run training on Mental Capacity Act and DOLS for care home providers, part of our workforce development. So there is training there, but one of the remits of the DOLS team was to provide training to managing authorities, and the partnership board that provides the strategic oversight and governance has instructed that we have to focus on actually assessing the people that are deprived of their liberty rather than using resource to train. So we're asking providers really to book onto the other trainings that are available and to get some of the training they need through the provider forum into online.
Sorry, Mandy, if I come in, do you think there is the problem of the care homes will think, to cover myself, I'll refer the person anyway, just in case something goes wrong, I'm then covered? That could then increase the number of referrals.
They may do that, but if we, for example, go out and do an assessment and then find that the person has capacity, then we would feed that back to the care home to say, actually, your capacity assessment here, you know, wasn't strong enough. You need to do some work about understanding that, because what we don't want to do is to use very valuable resources on the wrong people. So we do provide that feedback. But it would be good to be in a position to provide more awareness raising and training. I think actually it's probably more of an issue for hospital wards and hospital staff than it actually is for the nursing home and residential home sector.
Andy, you're happy with your bit now. Yeah. Can we move on then to Veronica? Do you want to carry on with yours?
That's better. In respect of the assessment process, how much of the assessment time is actually spent with the relevant individual? And do you think you've got the balance right?
There are 6 separate assessments that have to be undertaken by at least 2 different people. 2 of the assessments have to be undertaken by a Section 12 approved doctor, and the rest are, the other 4 are undertaken by the best interest assessor. You have to, in order to do those assessments, meet with the person themselves. So best interest assessors will go to wherever that person is and spend time with them. And those assessments are that they need to test somebody's capacity, and then they need to talk, and in doing that they need to talk to the person about where they're living, their care and support, are they happy with it? So actually a considerable amount of time can be spent with the person. They will always ask, what's the best time of day to go and see somebody? Are they better in the morning than the afternoon? Those sorts of things. If they need to go back, then they can go back, and go back as many times as they need to in order to do those pieces of work. And so there's no real limit on how much face-to-face time with the individual that the best interest assessor can spend. It's really down to professional judgment. How much time do I need to spend with that person in order to do a robust and comprehensive assessment? As a DOLS signatory, I have all of those assessments in, and I read them all because I'm tasked with scrutinising that documentation. So if I felt that actually it was light on that, then I can actually go back to the best interest assessor and say, I'm not prepared to sign that off yet. I'd like you to go back and see the person again. I think these things are missing. So actually I think there's quite a good level. Best interest assessors have their own professional judgment, and then there's a level of scrutiny about actually the quality of those assessments.
Do you feel that the increase in longer length dolls is in fact in the best interests of the relevant person, bearing in mind what you've just said?
Pre the Supreme Court judgment, Cheshire West, you would rarely see a dolls longer than 3 to 6 months, because the numbers of people that were deprived of their liberty were much less. Longer periods of deprivation, most of them now are for the whole 12-month period. Again, it's up to us, the supervisory body, to make a decision about whether we think that's appropriate and proportionate, based on the evidence that's contained in the assessments. For some people, it absolutely is appropriate. Maybe somebody in an older person's care home with the dementia, it's clear that from the assessments they're going to need that level of care and support ongoing. So actually a 12-month authorisation is reasonable and proportionate. There are other occasions, though, where you actually think, no, it's not. It needs to be a shorter period of time. And my experience is best interest assessors are very good at getting that right, actually. And again, if I'm signing off, or colleagues are signing off a deprivation of liberty authorisation, and we think that the period is too long or too short, then we can go back to the assessors and have that conversation. We don't have to sign it off because that's what they've recommended. And the key is, does the evidence contained in the assessment support the length of time that's being recommended?
Thank you. What review process and time frames are in place in relation to the increased length of time for dolls? So that's really expanding on what you've just said, I think.
I'm not quite sure.
The review and the time frames which are in place in relation to the increased length of time for dolls?
Within the dolls process, when you grant an authorisation, you write to the managing authority and with all the assessments, and they are required to notify the supervisory body if anything changes and makes them believe that the person shouldn't or isn't any longer comes under dolls. That's one thing. So there's one check and balance there. So you might have authorised for 12 months, but within that 12 months, the care home are responsible for keeping that under review, and there's a mechanism for them to go back to the dolls team if anything changes. And if the authorisation is due to expire or lapse, then at least 2 weeks before it should lapse, they must ask for a further assessment to see whether the conditions are still met, and a further authorisation is requested. What we have experienced in Torvine, and which is one of the reasons I went to the recent provider forum, is that care providers, managing authorities, were allowing dolls to lapse when in fact what they should have been doing was asking for that review. So where that happens, I went to remind them of their responsibilities, and also say to them it is their responsibility to make sure they know when the doll's authorisation is due to expire, and to ask in good time so that that can be reviewed. And if they don't do that, and if we continue to see dolls lapsing, then we'll use our commissioning SSD 180 process, because that's all about quality, to actually pick that up. And we've asked the commissioning team to make sure when they're going in and reviewing care homes and looking at quality standards, that the care home have got those processes in place so that we can avoid dolls lapsing, because that's poor practice.
Are delays in respect of the 21-day decision time actually impacting on the lives of individuals?
We should be able to do an assessment within that 21 days. What we already know is that we have this huge backlog of people waiting. So On the one hand, yes, it does impact, because we have people who we know are in situations where they're deprived of their liberty and we haven't been able to actually go out and do those assessments. So there is an impact. Whether that impact is actually experienced and felt by the individual, probably not actually, because of the nature of the people we're talking about here. They probably, you know, they wouldn't know anything about dolls. They probably wouldn't realise that that they haven't been assessed as yet. And actually, families are not particularly well versed in dolls either. So we're not seeing people complaining, if you like, that this should be done and it hasn't. But there is a risk that they will do that.
Just to check, I was thinking the first two questions on my list have already been answered. So we're going on to about the advocacy service. And say, I'm asking, have there been any appeals against decisions made by this local authority, this authority?
Sadly, no, which suggests that actually the safeguards are not operating in the way that government intended. And this is one of the issues that the Law Commission has raised, that because the appeals process is into the Court of Protection, actually it's not very close to the person themselves. And therefore we're seeing very few, well, none for Torvine. Nobody has appealed against this an authorisation made by this supervisory body. That is of concern, actually.
So in other words, you're saying that the saying about an appeal is in many ways, as it said, okay, and just leave it at that. There's no feeling that you like to see an appeal to maybe look at the system and say to further look at the system and how it's working. Did you see in that context?
Appeals are a number of levels, really. It's appeal for the individual against being deprived of their liberty. The outcome of that appeal might be that it's proportionate and right and proper. Nevertheless, it's to safeguard their human rights. So that's the avenue. The individual themselves, because they lack capacity, obviously can't bring that appeal. So it's the responsibility of the relevant person's representative to do that on the person's behalf if, and this is the tension, if they feel that that's what's needed. Sometimes families, quite often actually families, and it's a conversation best interest assessors have to have with families, are very happy with the arrangements of their person being in care. They're happy with the care they're receiving, and actually they don't really see why they would appeal. That kind of misses the point, because it's about somebody being able to exercise their rights. So if the best interest assessor feels that the family member is highly unlikely to make an application, they would probably choose an independent advocate, so an IMCA, in preference to a family member, explaining that to the family member. And our IMCA service, equally, have not taken up appeals to the Court of Protection. Feedback about that is there's no state aid, no legal aid to do that. So advocacy services either have to be represented legally themselves, or they have to, as an advocate, they have rights to go to the court themselves and represent the person. They haven't. I think that's probably a workforce development training issue for advocates. And actually the court, to actually get in front of the Court of Protection can actually take an awfully long time. It's not a particularly straightforward process. So we haven't seen any. And it is something that the Law Commission feels that the appeals system, again, is too bureaucratic, too difficult for people to be able to actually have an appeal. And what they were suggesting was a much more a system similar to the Mental Health Review Tribunal, which is extremely successful because it is very close to the patient. So yeah, it is something that is being looked at. It's, in my view, really unsatisfactory, because it tells me that these safeguards aren't actually, the appeal is the safeguard, if you like, so you have an independent court that will look at, is this right and proper and in your best interests? And if people aren't appealing that decision, then actually the safeguards themselves aren't particularly effective. Again, not a Torfaen issue particularly, it's that national picture again. Sorry.
So continuing on from there, I mean, you mentioned one idea, one possible, and would you say any future changes to the process as practice develops, and what impacts would it have on the actual service itself?
We are waiting for the Law Commission to publish its recommendations to government on a new scheme. The sort of legal commentators advise that that is due out in June. It's been a little bit delayed, I understand, because the Department of Health weren't initially satisfied with what the Law Commission were coming up with. So we're all kind of waiting to see what it is the Law Commission would recommend. Certainly in its consultation, it was suggesting, the Law Commission was suggesting something much more similar to the Mental Health Review Tribunal system. And I actually think that would be a very sensible way forward and would really make a difference.
As in our report, in paragraph 420, it talks about the Law Commission report, and as I said about the thing which you've already mentioned, anyway, which we mentioned with our last witness about changing the name of it, that a better name for it, a better label, a protective care, which I think, as when you hear the phrase deprivation of liberty, it does sound a bit draconian, and which you've alluded to, and also Tom, our last person, alluded to as well, that the family, when the family hears the phrase deprivation of liberty, they think somebody locked away forever and a day and that sort of thing.
They do, and usually it's been a very difficult journey to get to the point where they feel their loved one needs to go into residential or nursing care. And so if you see all of those things coming together, yes, it's not, it really is not helpful language. And if they did change the name, and I understand the Law Commissioner recommending this protective care, I think that would help families because it says something quite different.
Just before you go, can I, having taken in what you've already said, do you think Dols actually does what it's supposed to do? Because when I went through all the forms that I was given by the care home, the first thing that came across to me was this is an admin exercise and a tick box exercise, and it's very little to actually do with the resident itself.
I think if you understand where it came from, so way back, the Bournemouth judgment, and the government were found to be not compliant with human rights legislation, Dols was the government's response to that. And at the time, all the legal commentators were saying this is too complex, it will be very difficult for practitioners to operate in, and actually that's what it's found. We found, and we quite urgently need a review of that. That is recognised, and House Commons Select Committee said it's not fixable in its current form, because usually you would expect some revision to the existing legislation and guidance. They came to the conclusion that actually it's not even fixable. We need something completely new, and I think that my answer to your question really, no, it's not delivering what it's intended to deliver, because it is far too complex.
So my understanding then is, unfortunately, it doesn't do what it's supposed to do. It's hugely complex and expensive, but until it's changed, we've got to muddle along with something that isn't working, that we basically can't afford.
the moment, as it stands, yes, we have a statutory duty to operate within the current Dole's framework.
I think we'd say we have a managed process, though, rather than just muddle along. I think, you know, the criteria we've got... No, I don't mean that rudely, no, I do, you know, it's a very, very well-managed process with those, you know, the assessments that are done at the 3 or 4 levels. You know, and we're very lucky in Torvine to have somebody in Sarah who's an expert in this area, you know, where she would highlight, I think, if we were really found wanting, she'd be knocking on the door saying, we need some assistance in this area. So, you know.
Just out of interest, it seemed to take so long for this to get off the ground between 2005 and then we suddenly have these cases in 2014, and it seems as if then everything was put into place and you found that it just, as they say, went exponential in terms of 16 times what it had been before, and everyone's playing catch-up as a result. What was your position between 2005 and 2014?
Well, 2005 saw the Mental Capacity Act, but it wasn't until 2009 that the Deprivation of Liberty Safeguards came into being. What we do know is that actually 10 years on, or 11 years on now, Mental Capacity Act is not particularly well embedded across health, social care and anywhere else. People still see it as, because it's entitled Mental Capacity Act, to be the responsibility of mental health services, as opposed to actually, it's one of those things that's everybody's responsibility. When DOLS came into being in 2009, the threshold for what constituted a deprivation of liberty was much, much higher, which is why you saw very few people coming in, about 600 or so over that time, coming into the scope of the DOLS safeguards, because the threshold was higher for a deprivation. Everybody else, all those people we're seeing now, were probably restricted in some way, but the law said they weren't deprived. The big change has been the Supreme Court judgment, and I don't think anybody really saw that coming, actually, to prepare for it, because that significantly lowered the threshold to bring all of these people within now, that acid test, continuous supervision and control, and not free to leave. And so what's not caught up is the resources that are needed to mean that we can do that. So actually, probably in Torvine, between 2009 and the Supreme Court judgment, we were probably meeting the demands because those people that were then deprived of their liberty were being seen and authorisations put in place. It's this huge change that has made the difference, really, virtually overnight.
I just make one comment. I think that what members need to recognise, and I'm sure you do, is that nobody from a social care perspective goes into care without an assessment. Pre the Community Care Act, I would have had more concerns in this area then, because you would get families, in some cases, pushing people into residential care that didn't really need to be there. So in a way, they were being deprived of their liberty because they were... And I think, anyone that goes in now, there's a huge amount of scrutiny about their care needs, but not only that, about the resource implications for every authority. So I think, we need to balance that, don't we, in terms of what the current practice is and what this over-the-top, if you like, legislation has brought. And, we've got to abide by it. It is the law, but I think it's cumbersome.
Anybody else got any other questions for Sarah or Keith? Can I just say thanks ever so much for your input. You obviously know this back to front. Yeah. And as Keith said, I think as an authority we are very fortunate to have somebody with your expertise in the authority. Thanks ever so much. Really useful exercise. we've spent all this money having these people trained, but they're not actually doing because of their other, their other responsibilities. So I think we need to word something around that. We need to prioritise, perhaps, is the word, dolls, because it's pointless spending the money training all these people and having them there if they're not actually doing what we want them to do.
I was just thinking that's going to entail probably for quite a few managers a lot of pre-planning in terms of staff workloads. So that needs to be looked at quite carefully given the problems we've got with reductions in staff and so on.
Because obviously the answer is, if they're doing dolls, what are they not doing? So we'll be just shifting a problem from here to somewhere else. So it needs to be managed, as you say, very carefully.
I understand, because when they said about the 10 extra when they train for the pool and they're only doing one a month, sort of why is that really value for money, And they've gone through all that.
I think we should make a recommendation that the authorities, whoever they need to get the name changed sooner rather than later, because this deprivation of liberty. I know if it was my relative, I would immediately say, oh, hang on, whereas if you use the word protective, it would soften it so much more.
So, members, what I've got in relation to that perception is investigate what can be done locally and in the consortium to help change the negative perception of dolls with family members using the assessment process, because it's unlikely that we're going to be able to do anything with the legal system.
Just thinking about that and the relationship with families, can we perhaps look, rather than calling it dolls, start to move towards calling it protective care?
I'm into that. In relation to what the Chair was expressing earlier, I've got something to investigate how best interest assessors can be free to utilise their skill and carry out assessments moving forward. Investigate the provision of training to managing authorities and how that can be increased, considering their role in keeping the DOLS authorisations reviewed. Also, listening to the debate, I think that you were reassured and satisfied with the level of scrutiny within the DOLS process, to those checks and balances that are in place to make sure everything is okay. And I think you were pleased that the screening tool has been developed to prioritise those cases that need to be seen first, and it's also been adopted by Welsh Government. And you're also reassured by the very sort of managed process that existed with Torvine and for its partners as well.
Do we need to emphasise any more about the training of the care home staff? Have we got that covered? Have you got that?
Yeah, just the only thing I'd add. Sorry. They were talking about they have a form, like a standard form they send out in their letters to family members, talking about coroners, etc. We've talked about moving it more towards protective care, but perhaps we could look at having a standard pack that's given to families, because they're saying they don't get any appeals because families don't understand what it is. Even if they are being told, it doesn't seem like they have really any idea what the process is about. But if they were given something out, at least, presumably most care homes are, but we don't know whether all of them are,
Do you mean sort of you give an information pack to relatives saying, this is the DOLS, but
just a little...
Yeah, I agree, but it needs to be worded very well so that it doesn't have an adverse effect.
Yeah.
Nigel?
Also, I was interested by the remark about the advocacy service and the fact that where the advocacy service is strong enough. And I think one of the most fascinating things was when Sarah said that she actually welcomed appeals to the service, because the thing is that sometimes that maybe she thought that the people just said okay and leave it at that, and that she actually welcomed some further scrutiny and appeal on the service to maybe look at, to maybe a chance to look again. I think that was that was a fascinating piece. That.
Anybody else? We're all. I was going to say we'll be all happy. We're not happy, but yes, we're happy with the recommendation. Everybody okay? Yes, it was. Yeah. I know when you first read the report, I thought this is a bit dry, but it's actually not, and it's something I wasn't aware of, that we had the problem is this.
And I thought Sarah was really, really informative. She knows her stuff, and I think she's been really helpful, and we are fortunate to have her in Torfaen.
Okay, and I always get this wrong, because I always miss that out. Go on to the next agenda item, which is the next item for next meeting.
Yeah, the next meeting will be a visioning meeting, where we look at all the streams of information coming in. You'll be deciding your work programme, or what basket items can appear in your work programme going forward for next year. Okay.
And the date of the next meeting?
It is the vision on the 29th of June.
I just need to say thanks very much for your attendance and your contributions. Thank you, and I'll close the meeting.